Hello, everyone. In this lecture, we will be discussing the Bill of Rights, which is the first 10 amendments to the United States Constitution. Previously, we've talked about our first effort at establishing a government under the Articles of Confederation. And we determined that the Articles failed for a number of reasons. I think the most important one was that Congress had no ability to levy taxes under the Articles, and therefore no way to support itself and to enforce any laws that might have been passed under the Articles of Confederation. Another one was that there was no effective way to regulate commerce. So with this Constitution, those defects and the others that we discussed were remedied, or at least there was an attempt to remedy it. Um, but as soon as the new Constitution was completed in the summer of 1787, it was delivered to all of the states and published in every newspaper. And the thing that happened next was that all of the states had to uh, examine this new constitution and decide whether they wanted to adopt it. And the adoption process is called ratification. Each state would hold a ratification convention and debate the issues that were contained in uh, this new constitution. And one of the things that was perceived almost immediately was that there was no Bill of Rights in the new Constitution. Many states had their own Bill of Rights in their state constitutions. So one of the defects that was quickly pointed out was there's no Bill of Rights here. Alexander Hamilton, who was a Federalist, said that he didn't believe that they needed a Bill of Rights because everyone, every issue, every power that the new government had was specified in Article 1, Section 8. This is what he said. Now, I should mention that as part of the ratification process, Alexander Hamilton and James Madison and a third gentleman named John Jay drafted a series of articles called the Federalist Papers. And each one of these papers addressed a different aspect of this new Constitution, which they Madison and Hamilton and John Jay felt needed to be expressed to the people so that they could understand what this new Constitution was supposed to do. Uh, it's a invaluable resource to go back to the Federalist Papers and read what they had to say, what the people who drafted this Constitution had to say about it, and what they felt people should understand that the new Constitution would do. In addressing the issue of the fact that there was no Bill of Rights in the Constitution, Alexander Hamilton wrote this in uh, Federalist to paper number 84. He said, "A Bill of Rights, in the sense and in the extent in which they are contended for, are not only unnecessary in the proposed Constitution, but would even be dangerous. They would contain various exceptions to powers which are not granted, and on this very account would afford a colorable pretext to claim more than were granted. For why declare that things shall not be done which there is no power to do?" On the other hand, Jefferson, who was not a Federalist, had serious misgivings over the absence of a Bill of Rights. Um, he didn't really trust Hamilton's suggestion that Congress would only be able to do those things that were in the Constitution. There were a series of anti-Federalist papers published also, and in one of these, Brutus number two wrote, uh, "We find that they have, and to do this, let's take a look at the Constitution so we know exactly what it is that uh, this fellow Brutus Brutus is complaining about. All of many of these papers were written under pseudonyms. But so let's take a look at the Constitution and see what it is that he is concerned about. So he says, we find that they have in the ninth section of the first article, And this is the first article, Article 1. Let's scroll down to number 9 so we know what he's talking about. There it is. He says, we find that they have in the 9th section of the first article declared that the writ of habeas corpus shall not be suspended unless in cases of rebellion, that no bill of attainder or ex post facto law shall be passed, that no title of nobility shall be granted by the United States, etc. If, as Mr. Hamilton suggests, everything which is not given is reserved to the people, what propriety is there in these exceptions? Does this Constitution anywhere grant the power of suspending the writ of habeas corpus to make ex post facto laws? You see his point. Here is the language that he's concerned about. This does say habeas corpus shall not be suspended except if in case of invasion. You can't pass any of these things, bill of attainder, ex post facto laws, any of those. And it's true that nowhere in the Constitution does it say that those things can be done. So it seems that it would be implied that the power to do these things would be there unless it was expressly stated that they can't. It's a good question. Well, the question of exactly what power this new government under this new Constitution was going to have over the existing states was significant. It was significant enough that while a number of states did ratify fairly quickly, when the Constitution reached Massachusetts, Massachusetts dug in its heels hard. And John Hancock, who was the chairman of the Massachusetts Ratification Convention, stated that they would not ratify unless there was a guarantee that a Bill of Rights would be attached. And that was the deal that they ultimately reached. John Adams and John Hancock made a compromise that they would provisionally ratify this Constitution provided that immediately a Bill of Rights would be added to it. Once that deal was reached with Massachusetts, the remaining states, New Hampshire, Virginia, and New York, they all ratified, each of them ratifying on a condition that a Bill of Rights would be adopted. And the chore of drafting the Bill of Rights came to James Madison. Madison is sometimes referred to as the architect of the Constitution. He had so much to do with the drafting of it, and certainly he is the one who drafted the original 12 amendments to the Constitution, which he proposed should be added as what would be called the Bill of Rights. Now I say 12 because he did draft more than the 10 amendments that actually passed. The two that were not passed, one of them, it was probably good that it did not pass because it would have linked the size of the House of Representatives directly to the size of the population of the United States, and making the House of Representatives terribly unwieldy. There would be thousands of members in it now if it had passed. The other one, which did not pass, now stands as the 27th Amendment to the Constitution. So it ultimately did pass. This 27th Amendment, we'll look at that in the next lecture or in a subsequent lecture, says that if Congress votes itself a pay raise, that pay raise doesn't take effect until after the next election cycle. So those are the two that did not make it into the original Bill of Rights. I'm going to take a look at the Bill of Rights one at a time, but first of all, let's keep in mind what the original intent of the founders was, so that in drafting and adopting this Bill of Rights. The original intent was to protect the states from this newly powerful central federal government. So the Bill of Rights originally only applied to the federal government. It's an oddity that only after the passage of the 14th Amendment did bits and pieces of the Bill of Rights begin to be applied to the states. We'll take a look at that in a minute. But there is case law from, for example, the case of Barron versus Baltimore in 1833 expressly stated that the Bill of Rights only limits the federal government in its action. It does not limit the states. So uh, what that means is that the rights that are found in the Bill of Rights have been gradually applied to the states, never all at once, though. And that really comes down to the way that the legal system works. A court has no authority to rule on something which is not directly before it. And by that I mean if there's never been a case where all 10 of the amendments in the Bill of Rights were before the court in a way that the court had to rule on them in order to resolve the case. One example is the requirement in the Fifth Amendment that any capital case must be set in motion through a grand jury. Now, a grand jury is an investigative body which is used to determine whether there's enough evidence to prosecute the case. It's not used in all cases. It's used in many cases, though, and in the state of Florida, for example, it is used to commence a death penalty case, where the death penalty is a possible sanction. The United States Supreme Court has never had a case where that part of the Fifth Amendment was directly in front of it, and consequently, that's one of the few rights that's found in the Bill of Rights that's never been applied to the states. Most states that have capital punishment have it as part the requirement of a grand jury as part of their state constitutions. So it's not really been an issue. But that's an example of one that has never been applied to the states. The remainder of these that we're going to talk to have at one time or another gradually been applied to the states, bit by bit, piece by piece. So we're going to start with the First Amendment. So let's take a look at what the language of the First Amendment is. Scroll down here to the First Amendment. Here we are. Now, very interesting language here in most of these constitutional amendments. Amendment 1 contains a bunch of rights, all in that one amendment, and they are not necessarily related. But here they are. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That's the religion clause. Or abridging freedom of speech, or of the press, or of the people peaceably to assemble and to petition the government for a redress of grievances. So there's all these different rights all jumbled together under Amendment 1. So let's start with the right to freedom of religion. This case, this right was discussed by Thomas Jefferson, and his description of it was that this effectively places a wall of separation between church and state, and that's kind of how the Supreme Court has interpreted this, as saying that there needs to be some kind of a protective wall that precludes the government from interfering with your right to exercise your religious beliefs in a way that you feel is appropriate. The best case that I can give you that addresses this part is the Lemon test. And let me pull that up. That case is called Lemon versus Kurtzman. Here's the case. Lemon versus Kurtzman, decided in 1971. And what happened in Lemon versus Kurtzman, I'll give you the case very briefly. The facts of the case briefly is this. There was a private school that wanted to teach science. It was a religious school, but they sought to hire on a temporary basis public school teachers to come to their religious school and teach science in the same way that it is taught in the public schools. The school board in Pennsylvania felt concerned about this because they knew about the First Amendment's restriction on mixing religion and government, and these were government employees being sent to teach science in a religious school. So what they did was they said, all right, we'll permit it, But what we're going to do is we're going to send in monitors who are going to drop in periodically to make sure that they're just teaching science and not mixing science up with religion. And that case was taken up. Somebody sued over it. They felt that it was improper, the way that the school board was handling it. And it went up to the United States Supreme Court. And the court said in Lemon v. Kurtzman, I can stop sharing the case now so we can talk about it. There's a three-part test under the Lemon test. First, does the law or the government action that we're talking about have a secular, meaning non-religious, legislative purpose? So in this case, do we meet that test? Yes. They're just doing this to give a science education to students of religion who would in a religious school. Two, does the government action we're talking about neither advance nor inhibit religion? And they concluded that having science teachers teach that subject in a religious school, it was neither advancing nor inhibiting. They were merely teaching science. Number three, and this is the sticking point here, does the government action avoid excessive governmental entanglement with religion? And this is where the school board fell down. And, you know, it's also rather difficult to apply. Number one is a simple yes or no answer. Does it have a non-religious purpose? Number two is also a simple yes or no. Does it neither advance nor inhibit religion? But number three requires a certain amount of judgment. What is excessive government entanglement with religion? In this case, the U.S. Supreme Court felt that hiring monitors to go in and assess whether they were teaching purely science or whether they were also teaching some form of religion was too much. It was excessive government entanglement with religion because apparently the monitors were going to have to assess what was going on. So that's the test that is still used today to measure whether government's involvement in religion is appropriate or must be curtailed. All right, so we're back to First Amendment, and let's pull it up here again and take a look at the next subsection. The freedom of speech and of the press. Well, there are some limits on the freedom of speech. It's never occurred in this country, but there used to be such a thing as prior restraint, which when in England, the government did not always trust this newfangled idea of a printing office. And so all print offices had licenses. And as part of that licensure, the government would periodically drop by and see what it is that they're printing. And if they found that they were printing something that the government did not want them to print, they could stop it. That's called prior restraint. We've never had that in this country. But we do have limitations on freedom of speech. There are some things that you are not permitted to say or talk about. What about there's a famous a famous act by George Carlin called 7 Dirty Words You Can't Say on Television. And I'm not gonna we're not gonna watch it here, but he does a very thorough and there's a certain wisdom to his approach to this subject. And indeed, the 7 words that he identifies as being the words you can't say on television are still probably pretty accurately described. We still could not say these things on television for the most part. But why is that so? Why can we say words like 4-letter words out in public, but you can't say them on television? That's got to do with because of the Federal Communications Commission. When radio was invented and television came shortly thereafter, it was pretty early on determined that there was a limit to the amount of bandwidth that was going to be available to the broadcasting people. And so the government decided to take control and license these things. And in the course of licensing them, they determined that certain kinds of language should be restricted. They wanted the programs to be such that a child could listen to them, and the parent would not object to what was being said or presented during the presentation. So that's one limitation on our speech. The government restricts certain things from going out on the air. Now they've since governed altered that in some ways. Now they have a sort of a family hour, and you can put on something of a more risque nature after a certain time. But that's a limitation. Potter Stewart, Supreme Court Justice, said, I don't know, I can't describe what pornography is, but I know it when I see it. But freedom of speech is considered necessary for the proper function of government, and obscenity itself is defined by the United States Supreme Court in a certain way. Let me see if I can pull up the case for that. Here it is. This is Miller versus California. In Miller, the United States Supreme Court was faced with how do we define obscenity? And again, Potter Stewart did say he knew it when he see it. He knows it when he sees it, but actually defining it is difficult. What they concluded in this case was there's a three-part test. They love these three-part tests, apparently the Supreme Court does. And this is what the test is: whether the average person applying contemporary community standards would find that the work taken as a whole appeals to the prurient interest. Is it sexual in some way? And is it appropriate applying contemporary community standards that work should be presented to the public in that community? I'll come back to that test in a minute, because that's really significant to how we define obscenity. Secondly, whether the work depicts or describes in a patently offensive way sexual conduct, specifically defined by the applicable state law that we're talking about. And number three, whether the work taken as a whole lacks serious literary, artistic, political, or scientific value, utterly without redeeming social value as part of the test. All of these things are pretty slippery in terms of how you go about defining them. But let's get back to this contemporary community standards thing, because that's the most interesting part of this test. Many years ago, I worked as a prosecutor down in Sarasota County, and an officer, a deputy sheriff, came into. I was working as the chief of the misdemeanor division there, and he came into my office, and he dropped 3 recordings, cassette tapes. VCR, I think they were. This tells you how long ago this was. Dropped them on my desk and said, these were in an adult store and they constitute their pornography, they're obscene. Well, okay, I said we would look into it. So I brought all the prosecutors in the division in and said, we have to watch these tapes to determine if they're obscene. And so all of us sat in a room and we watched these adult pornography, allegedly pornography, adult videos. And after watching all of them, we concluded that under what we felt was the contemporary community standards, this was just your run-of-the-mill adult film, and there's nothing unusual about it. And we decided that we did not care to prosecute it. But that's not really the way that it should be done. We felt that it was not terribly offensive, but the right way to do it, if you really did have a feeling that this was something that did not meet the community standards test, would be to put on those videos in front of a jury, let the jury decide. Some years ago, here in Tampa, where I am, there was a case against a adult film distributor whose name was his internet name was Max Hardcore, and he distributed adult films over the internet. He advertised it through the internet, and he would then take payment, and the film he would mail it to you. And so some people here in Tampa contacted him and ordered some of his I'm calling them films, but I think by that time he was using DVDs, compact discs. And they ordered some from him, and they received them through the mail. And on reviewing them, they immediately convened a grand jury, and they brought Mr. Max. He was living in Colorado at the time. Here, arrested him and put the videos on for the jury to look at, and the jury found him guilty of distributing pornography, obscene pornography. And he was sentenced to a prison term. So the thing is that what are the community standards? Well, that's how we determine what the community standards are. It's by bringing in members of the community and letting them decide. So that's obscenity. Next on our list, let's go back to the First Amendment, because there's a lot there. It really is. That's freedom of speech or the press. Now there is something else about freedom of speech which we have to talk about, and that is there are limits to what you can say. If we were in the same room and I were to approach you with my fist balled up like this, and I were to tell you I'm going to punch you in the face, am I allowed to say that? And the answer is no. I've actually committed a crime. I've committed the crime of assault, which is the threat to do force with the apparent ability to carry it out. So, yeah, I can't do that. I also, those are called, fighting words. We cannot incite a hostile crowd to commit an act of violence. That too is a limitation on our freedom of speech. Hate speech. If in the course of committing a battery upon you, I also tell you that the reason why I'm committing this battery upon you is that you're a member of, whatever kind of minority group that I'm thrashing you over. If I tell you that's the reason why that I'm thrashing you, that constitutes hate speech, and hate speech can be used to enhance a jail sentence if I'm convicted of committing that offense, and that too is a limitation on what I can say. There is also a limitation on religious speech in public property. Now, there's a difference between religious speech on a street corner. It may be offensive to you that somebody may be preaching on the street corner, but that's usually a public forum, and there's not much that can be done about that. But preaching the religion inside of a public building is that too. That is limited. So, all right, those are pretty much the limitations on freedom of speech. Let's the other rights that are here in the First Amendment are the right of the right of the people to peaceably assemble, and that too is if you apply it strictly is can have some unusual consequences. Back right after World War II, people were investigated for being members of communist groups. Now, what would be wrong with being a member of a group that was attempting to influence the government to become more communist? Well, in those days, it was punishable, and it was not necessarily punishable directly by the government, but private enterprise would, if you were found to be a member of a communist group. Many people who were involved in the film industry were blacklisted from the film industry for being involved in a group of that sort. Now, The federal government, here's the thing about these rights. What we're talking about is rights that the government cannot infringe. A private person can infringe on some of your rights. There's nothing stopping me from stopping someone else from saying something that they have a right to say. Government cannot stop you from saying things that you have a right to say. So, all right, that's really all of the First Amendment that I want to cover. Let's move on to the Second Amendment. This too is a favorite of discussion. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, we saw something of this in the English Bill of Rights, where the English Bill of Rights actually says that not all people have the right to keep and bear arms. Only Protestants are allowed to keep and bear arms. But we've expanded the right, apparently, not merely to applying to people of a particular religious faith. For a long time, the argument was that the right to keep and bear arms had to do with the keeping of a well-regulated militia. The thing is that this refers to a time when there was no police force, and in fact, most cities had no regular police force, and if there was policing that needed to be done, it was done by the local militia, which would be us. And so that's what that language means, a well-regulated militia being necessary to the security of a free state. People were entitled to keep and bear arms because they might be called upon to do their militia thing and go arrest somebody who was had committed an offense of some kind. So when the U.S. Supreme Court finally did address this, they concluded that the right way to interpret the Second Amendment is really to view this first section as surplusage and just go right to the heart of it, that the right of the people to keep and bear arms shall not be infringed. And the first case to address that is this one, District of Columbia versus Heller. This case, which was decided in 2008. And in this case, the District of Columbia had a district-wide ban on handguns. Mr. Heller had a handgun, and he was arrested for being in possession of a firearm. And he took it to the U.S. Supreme Court and argued that the Second Amendment gives him a right to carry a firearm. And the Supreme Court agreed. For the very first time in 2008, they directly addressed the question of what does the Second Amendment mean, and they answered it in the affirmative that, yes, you have a right to bear arms, to arm yourself. And because this case only applied to the District of Columbia, it was not immediately adopted on a nationwide level. It was not until the following case, which was McDonald versus Chicago, was decided 2 years later. Let me show you that case. This case, McDonald versus Chicago. Chicago had a citywide ban on handguns, as did the District of Columbia, and the Supreme Court, relying upon its precedent in D.C. versus Heller, again ruled that under the Second Amendment, Chicago did not have the McDonald had a constitutional right to carry a firearm if he chose to do so. So that's the Second Amendment. It's been interpreted for us. The Third Amendment, I am not aware of any case that has yet interpreted the Third Amendment. But the Third Amendment tells us, I'm just going to read it here rather than sharing the screen with you. It says, no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So we have not ever had that issue come up. So it's certainly a thing that they were concerned about, that the government might do, because the British government had done that to us in the past. But so far, our federal government has never done that to us, nor has any state government done that to us. So we next move on to the Fourth Amendment, and my discussion of the Fourth Amendment is going to be fairly lengthy. So let's dig into it. What does the Fourth Amendment say? The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Now, the reason why my discussion here is going to be lengthy is I like to explore, along with our discussion of the Fourth Amendment, the issue of the right to privacy, because the Fourth Amendment is directly related to this right, the right to privacy. And I start with the early 1960s. Now, one thing that happened in the early 1960s was the development of the birth control pill. And the birth control pill was a revelation, particularly for women, because for the first time ever, this was a fairly effective way for a woman to control whether or not she was going to have a child. There were methods of contraception before that, but they were largely controlled by men. And the ones that were available to women didn't always work, and if they were uncomfortable. If they did work, they were uncomfortable. So for the first time, women had the right to control whether they were going to have a child. And there was a great to-do about this when the pill was released and made available to women, because people thought that the women were going to go crazy. I don't know, maybe they did. But the adoption of the use of the birth control pill was restricted in some places, which is an odd thing. In Connecticut, there was a law. Let me see if I can pull this up. Hang on a second. I gotta find my case here. Yeah, now I've got it. Let's take a look at this case, which is Griswold versus Connecticut, decided in 1965. Connecticut had a long-standing ban on the use of any drug to further contraception. And in order to test this law, a gynecologist opened a birth control clinic, and they were challenged as to whether that law from 1879 was valid. And the question was really limited to marital privacy. Does the Constitution protect the right of marital privacy against state restrictions on a couple's ability to be counseled in the use of contraceptives? And that was the issue that was squarely before the U.S. Supreme Court. And you will notice that all white men deciding this case. And the outcome of this is particularly interesting to me, because they found a brand new right that was not in the Bill of Rights, is not in the Constitution, but they said it can be inferred, and that right is the right to privacy. They looked at a number of different areas of the Constitution, and they said that look, you have a right to under the First Amendment, a right to peaceably assemble with the people that you choose to peaceably assemble with. Government can't interfere with that. The Third Amendment says the government can't stick a soldier in your house without your permission. The Fourth Amendment, which we're looking at now, says that the government cannot search your house without probable cause. So they felt that there is a right to privacy, and this privacy certainly covers a married couple's decision of whether or not to have children. And they struck down this decision in Connecticut, this law in Connecticut that prohibited that kind of government involvement. There was no reasonable explanation for why government should be invading that area that to which we have a right to privacy. The next case that interprets this newly found right to privacy addresses not married couples, but singles, and that's Eisenstadt versus Baird. And in this case, it's a similar issue, but in this case, it was a woman was given a encovaginal foam, a contraceptive. And the Massachusetts law that prohibited the giving of birth control to either to unmarried men or women was challenged. And the United States Supreme Court said there is no reasonable explanation for there's no, they said that they used the rational basis test. There was no rational basis for government to be involved in married couples, as in the Griswold case, or the right to privacy of an individual to determine whether, for an individual to decide whether they were going to have a child or not, whether they're married or single. So this is an extension of the right to privacy. And you see when this case was decided, 1971. Now, the next case, hang on just a quick second while I pull it up here. You're all familiar with it. And that is decided the very next year, Roe versus Wade. And in this case, it too is decided on the basis of this newly discovered right to privacy. The Roe court explored when they explored the issue of viability, and they concluded that a woman's right to decide whether or not she is going to continue having the child is determined on the basis of whether the child can survive outside of the womb. The first 3 months, certainly, the child could not, and there's a question during the second trimester, and certainly not during the third trimester. So what the court said in Roe was a woman's right to privacy governs her right to have an abortion. If the woman decides that she doesn't want to continue the pregnancy, she's authorized under Roe to do that, to discontinue that pregnancy. Now, we know also that the Supreme Court a few years ago overturned Roe versus Wade, and we'll talk about that later when we talk about the judicial branch, because that is really a question of judicial philosophy and how to interpret the Constitution. But we're not there yet, so I'm going to hold off on having that conversation with you. But this exploration of the right to privacy does not end with Roe versus Wade. It also extends into same-sex sexual activity. In this case, Bowers versus Hardwick was decided in 1986. This case, it's a little bit difficult to talk about, but let me just spell it out. There was a time when states criminalized certain forms of sexual activity, and they made a distinction between natural and unnatural sexual activity. Natural sexual activity, which is sort of got a biblical interpretation there, is any kind of sexual activity that could result in childbirth. Unnatural would be those kinds of those forms of sexual activity that could not. I'm not going to spell it out. You got to use your own imagination there. So what many states did, Florida included, was they criminalized unnatural sexual activity, so that the only kind of legal sex that there was the natural type, which could result in childbirth. Now, that's interesting, and it's also past history, but we're talking about 1986, so it's not that far back. Why should the government be involved in this? Why should the government care? Well, you have to remember that in government, even though we have separation of church and state, there are people of faith in government, and people of faith frequently take their beliefs with them. They don't have to leave their beliefs at the doorway when they enter Congress. So the biblical prohibition against unnatural sexual activity was carried into the law by people of faith, most likely. So in Bowers versus Hardwick, now the thing is, people who are male-female couples can engage in sexual activity that would be natural and therefore not unlawful under the old regime. But what about gay couples? Whether they intended to or not, the effect of laws that forbade unnatural sexual activities directly hit homosexual couples, gay couples. The only kind of sexual activity that they could engage in would be the illegal kind. And so what police officers would do would be there have always been gay bars. They would go to a gay bar and when approached and asked if they wanted to engage in some kind of sexual activity, that gave them a reason to arrest this person and charge them with soliciting them to engage in an unlawful act. It was shameful behavior, but they did it quite regularly. And in fact, that's what happened in Bowers versus Hardwick. The court was asked to determine whether there is a right for homosexuals to engage in. Let me show you the case here so that you can see. This is Bowers versus Hardwick, decided in 1986, and this term here is the technical term for any unnatural sexual activity. The question is it does the Constitution confer a fundamental right upon homosexuals to engage in this kind of sexual behavior? And the U.S. Supreme Court said, ew, that is not going to be, we're not going to allow that. And so they found that there was no constitutional right, despite the privacy things that they had been talking about earlier, that doesn't extend to homosexual activity. And that's 1986. That did not remain the law, however. Some years later, in 2003, the U.S. Supreme Court revisited the same issue in Lawrence versus Texas. And in Lawrence versus Texas, they finally got it right. I mean, it's under an equal protection argument. If married couples can engage in it, why can't individuals, same-sex couples? So the conclusion here was that even though the court was kind of split on it, the right to liberty under the Due Process Clause gives them the full right to engage in their conduct without intervention of the government. So there's no legitimate state interest in intruding on the personal and private life of an individual, whether they're homosexual or not. All right, so that's kind of an odd extension of the effects of the Fourth Amendment. This establishing of a right to privacy and the effects of establishing that there are certain areas of our life the government should not be invading. So let's go back to the actual language of the Fourth Amendment, and we're going to talk about search and seizure now. In this case that I'm about to pull up for you, Katz versus United States, the U.S. Supreme Court explained what is meant by a search and under what circumstances is a search unlawful. And in this case, the court said that law enforcement or government may not conduct a search of an area that is generally considered where the person has a reasonable expectation of privacy. We're still extending this notion of privacy. If you have a reasonable expectation of privacy, the court needs to give you a search warrant before you can conduct that search. Only in places where you do not have a reasonable expectation of privacy is a warrantless search going to be authorized. All right, so Um, Under the Fourth Amendment, so we have searches that are conducted with a warrant, and then we have searches that are conducted without a warrant. So a warrant would be where the police officer develops what we call probable cause, which is when I explain this to a judge, when a police officer explains it to a judge, the judge would agree that that establishes that there's probably criminal activity going on. Not definitely, just probably. So the officer would require a warrant under those circumstances, but there are exceptions to the warrant. And here's what my list of exceptions would include. First of all, if the officer asks you for consent to search and you give the officer consent to search, well, they don't need a warrant. Many times, if you're stopped in your car while you're out driving, and the officer says, "Do you mind if I search your car?" and you say yes, well, you just you've thrown your right to privacy out the window. The officer is allowed to search your car if you give consent. The officer is allowed to search your person if you give consent. Um, Another area where there is an exception is if the officer has just arrested you. They have the right to search your person and the area in your immediate vicinity for weapons or anything that might be harmful to the officer arresting you. A third is plain view. If the officer is standing in a right where the public generally has the right to stand, and from that position they can see that there is evidence of crime going on, they can seize that evidence. For example, if an officer sees standing in the sidewalk out in front of your house, sees that you are growing marijuana inside one of the bedrooms of your house, the officer can seize that without a warrant. Another exception, hot pursuit. If the officer is in hot pursuit and the person that they are pursuing runs into your house, the officers can follow them into your house. And while they're in your house, if they happen to see evidence of some criminal activity that you're engaged in, they can seize that evidence. My next to last one, is exigent circumstances, and that's where there's an emergency of some kind. An example of this is a case that I worked on many years ago where the officers saw a gentleman that he knew. And this was somebody that he had arrested many years before, and he was someone who had a history of manufacturing methamphetamine. And knowing this information, the officer slyly followed this fellow around, and as he followed him, he observed that this defendant was purchasing things that, in the officer's experience, were consistent with the materials that he would need to manufacture methamphetamine. After the defendant bought all these materials, he then returned to his apartment and went inside the apartment, and the officer testified at the motion to suppress hearing, and he said that I'm familiar with the ways that methamphetamine is manufactured, and all of the ways of manufacturing methamphetamine are dangerous. And so, because of that testimony, the officer said, I therefore went into the apartment without a warrant. I seized the defendant, and in order to prevent him from engaging in these things that would be dangerous to the other residents of the apartment complex, and I secured him. After that, I went and got a search warrant, and he went in and with the search warrant and was able to find evidence that he was in fact manufacturing methamphetamine in the apartment complex. And the court found that kind of activity was appropriate. This was an emergency situation based upon the evidence presented by the arresting officer. Another exception is the Terry stop. And for that, I have this case that I'm going to show you. This is Terry versus Ohio, which was decided in 1967. And in this case, the police officer involved in the case saw two men. This was in the summertime, and the two men were dressed in overcoats. They looked odd because it was hot out, but yet here these guys were dressed in heavy clothing. And the officer observed them looking through the window of an appliance store, and they walked down the street a little bit. They chatted between themselves, and they came back and looked in the window of the store, and then chatted a little bit more. And the officer felt strongly suspicious that they were casing the place, getting ready to rob this appliance store. And so he approached and asked them for identification, and he patted them down. And the Terry stop allows an officer to stop you briefly in order to ask you questions about what you're doing and why you're doing it. And in order to do this, the officer has to have what is called an articulable suspicion that criminal activity is about to occur. Articulable suspicion just means something that the officer can say to the court that makes sense to the court. Yeah, that sounds suspicious. A Terry stop is a brief stop. It's only long enough for the officer to ascertain whether you have a reason for acting the way that you're acting, or whether there's criminal activity ongoing. It does not authorize a lengthy stop. It's a brief stop. And the nature of the pat down is to search for weapons. While the officer is patting you down, if the officer finds something that feels like a bologna sandwich in your pocket, the officer really doesn't have any basis for thinking that that's dangerous. But if the officer feels something that feels either like a knife or a gun, the officer can remove that from your pocket in order to secure it. So that's the Terry stop. All right, I think that's about as much of the Fourth Amendment as I want to go over. Let's move on to one of the next amendments, which is the Fifth Amendment. Let's look at the Fifth Amendment. The Fifth Amendment is one of these amendments that has a number of rights discussed in it. It's a collection of rights. The majority of them are dealing with criminal activity, but there is one area that is not. So we'll start at the beginning. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Now, we talked about this a minute ago. If you are charged with a capital crime, which means one where the death penalty is a possibility, in the federal system, you are required, the prosecutor is required to get an indictment from a grand jury. Why is this so? Why is this right so important? Well, if I'm the prosecutor, and let's say that I'm the evil prosecutor, and I have something I don't like you for some reason, and so I arrest you for murder. Once you've been arrested and charged with a serious offense like that, there are going to be people who believe that you did it, even if you're found not guilty. People just kind of feel that way. Where there's smoke, there's fire is the idea. So in order to prevent that kind of government overreach by evil prosecutors like me, the courts require that where there's a serious offense, I'm contemplating charging you with a serious offense like murder, there has to be a grand jury involved. And as I said, the U.S. Supreme Court has never applied this to the states, but most states, all states, so far as I know, have this requirement of a grand jury in their constitutions. Florida certainly does. We'd never prosecute a death penalty case without getting a grand jury. So the next right that the Fifth Amendment grants is one that you're probably a lot more familiar with, which is nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. So this is the double jeopardy clause here. If I have prosecuted you and the jury finds you not guilty, I cannot say, oh, well, that jury was just dumb. Let's get another jury in here that's got a little smarter jury, and we'll try it again. I can't do that because you've already been tried, and you're not guilty. I can't retry you. The exception to that is if there is another government, which there is. The state I'm a state prosecutor who is prosecuting you and found not guilty. If there is a same statute covering the same activity on the federal level, the federal government can prosecute you for the same activity, and that's not subject to the double jeopardy clause. So that's the one exception. This next one, nor shall any person be compelled in any criminal case to be a witness against himself. And that's where you would say, I'd rather plead the Fifth Amendment. When you plead the Fifth Amendment, this is the part that you're pleading. I can't, as a prosecutor, I can't force you to testify against yourself. And not only that, I can't comment on that fact to the jury that you did not testify on your behalf. It would be if I said that, well, why didn't Mr. Freeland testify? Because he was certainly there when the victim was killed. Why didn't he step forward and explain what happened? That would be the same thing as not having no Fifth Amendment right at all. So I can't be compelled to be a witness against myself. And the extension of that is that the prosecutor is not permitted to comment on the fact that I did not testify. This next right, you cannot be deprived of life, liberty, or property without due process of law. And that's due process requires a little bit of explanation. We talked about it briefly when we were looking at the Magna Carta. But due process merely means a procedure that is expected. It's an expectation of fair treatment. That the rules of procedure that are going to be applied to me are the same rules of procedure that apply to everybody. An entitlement of due process. So that's, we don't just make up the rules as we go along. We know what the rules are, and everybody follows those rules. That's what that means. Finally, this last one, it kind of sticks out like a sore thumb because it has got really nothing to do with any of these previous ones, nothing to do with criminal law. But this says, nor shall private property be taken for public use without just compensation. And this has been applied to the states. And what occurs here is when the government is going to take property for public use. Let's say you have property that's on the side beside the interstate, and they've decided to expand the interstate. They can take your property if it's for public use. And if they do take your property, they have to, as long as it's for a public purpose, you really don't have a challenge to that. The only challenge that you can make is to whether you're being paid just compensation. But that's really what all that means. That's an oddity of the Fifth Amendment. We move on to the Sixth Amendment. This too has a number of rights all jumbled together, but all of these are related to the criminal prosecutions. You have a right to a speedy trial and a public trial. Now, in Florida and in most jurisdictions, a speedy trial is defined by how serious the offense is. If you are charged with a felony in Florida, you have to be brought to trial within 6 months of your arrest. And it's a pretty strict rule. If we don't bring you to trial within 6 months, the case can be dismissed. Although bear in mind that, as with many things, your right to a speedy trial, you can waive your right to a speedy trial if you so choose. And many times, if your lawyer is getting ready for trial and is not ready yet, they can ask for an extension. And by asking to extend the trial date, you are waiving your right to a speedy trial. And so in felonies, it's 6 months, and in misdemeanors, which are the lesser offenses, it's 90 days. So that's the general rule for speedy trials, and I think all jurisdictions follow that same basic rule. You are also entitled to a public trial. But why would you want a public trial? I mean, isn't that thing that you did kind of embarrassing, and you don't want people to find out that you did that thing, whatever it was, you stole that candy bar or whatever horrible thing you did. Yeah, you might not want that to be out public, but you're forgetting that I'm the evil prosecutor. And so if we have a private trial where nobody is watching, I'm going to pull every dirty trick in the book to try to get my conviction. And if we have a public trial, that prevents me from doing that kind of thing. This whole idea here is to prevent the public from overreaching by the government. And if you're having secret trials, well, there's no rules if the trial is a secret trial. You have a right to a trial by an impartial jury. This would be the trial jury, not the grand jury. Remember, there's a difference. The trial jury is the one that decides whether you're guilty or not. It needs to be held in the district where the crime was committed, and you can waive that right too. Generally, you are tried in the same district where the crime was committed, unless they determine that it's not possible for them to get an impartial jury, in which case they might move your case to a different county. The way that that's done is you attempt to get an impartial jury in the district, and if it becomes clear that everybody in the jury pool already knows all the facts of the case and they think you're guilty, well, you might want to move your case to a different county. So there's methods for doing that, but that's really what that means. You have a right to be informed of the nature and cause of the accusation. Yeah, they have to tell you what you've been accused of when you're being tried. You also have a right to be confronted with the witnesses against you. So this too is an important right. And the difficulty here lies in when you have a case where, let me stop sharing for a minute and just talk to you directly. If you have a case where there is a sensitive witness, what if it's a rape charge, or what if it's a child sexual abuse charge even? That victim is going to have to testify as to what happened. And this can be problematic for the prosecution because you have a right to face your accuser and have them testify that that's the guy that did that to me. It's difficult to get around, but prosecutors, when they are seeking to prosecute that kind of case, that's one of the factors that they take into account when they are deciding whether they can proceed with the trial. The next right in the Sixth Amendment, your right to be confronted with the witnesses against you. You also have the right to a compulsory process for obtaining witnesses, which means basically subpoenas, a court order directing witnesses to appear to testify. You have that right. And finally, perhaps I think the most important one of the Sixth Amendment rights, you have the right to the assistance of counsel for your defense. And for that case, for that particular right, I want to look at this case, Gideon versus Wainwright, decided in 1963. In this case, Gideon was charged with a felony, and as was fairly common in those days, he was taken to trial. He didn't have an attorney. Generally, they only gave attorneys to capital cases, and they didn't give him one. And he said, "Don't I have a right to that?" He sent a letter basically up to the U.S. Supreme Court, and the U.S. Supreme Court said, "Yes, you have a Sixth Amendment guarantee of counsel. It's a fundamental and essential right." So with this case, Gideon versus Wainwright, the Public Defender's Office was born. And while many people criticize the Public Defender's Office because they feel like the Public Defender's Office isn't doing them right, isn't spending enough time on their case, that's probably true. They are overworked. But of the people that I know that are in the criminal law business, the people that work in the Public Defender's Office are some of the true believers in the rights of their clients, and they work the hardest to try to get their clients justice. All right, so that's the Sixth Amendment. The next one, the Seventh Amendment, is not as exciting. What the Seventh Amendment says is if you have a civil suit where the value in controversy exceeds $20, you have a right to a trial by jury. And this also says that once the jury decides what the facts are, on appeal, the appellate court is not allowed to reassess what those facts are. That's an interesting right. It has nothing to do with criminal law. It's entirely related to civil suits, and it's still the truth. It's still of value. Except in federal court, if you want to have a civil suit, it's closer to $20,000 now that you have to have in order to get into federal court. Otherwise, you're going to be stuck trying your case in a state court. The next amendment, which is, I think, more significant. Forgive me for, a dog on the Seventh Amendment, but we'll move on to the Eighth Amendment now. And in the Eighth Amendment, let me share this with you. The Eighth Amendment says a few things, not as complex as some of the previous ones, but this is still dealing with criminal cases. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So bail, let me go through these rights one at a time. If you're arrested, in Hillsborough County, they have a bail schedule for nonviolent offenses. If you are charged with petty theft, you already know what the bail is going to be. It's a nonviolent offense, and they set a schedule. You know that you're going to have to come up with $5,000, for example, as a bail to get out. And what the purpose is that you have this money, a fund that you give to the clerk's office, and that's to ensure that you're going to come back for the trial. Once you've been arrested, unless you are able to bail out, if you can't afford to bail out, then what happens is that you go before a judge for what they call first appearances. And the judge then reviews the bail amount and will ask you questions such as, what are your ties to the community? Do you have a job? What kind of assets do you have? And all of these things are relevant to the judge's assessment of what is a fair bond amount. Bond and bail are interchangeable terms. So if the judge says, well, $5,000 bond is going to be what the bond is, well, then you have to go to a bail bondsman to get out. And so a bail bondsman usually requires some kind of collateral, your mother's house, for example, and you give the bail bondsman 10% of what the bond is, and $500, and then the bail bondsman says, okay, you can go, and you're out. Now, the $500 you give to the bail bondsman, you'll never see that again. That's the fee for basically he's babysitting you while you're out. If you don't show up to court, Dog the bounty hunter is going to come after you. So he or she has got to guarantee that you're going to be in court when you're supposed to. And if you don't, they will come track you down. So that's the bond requirement. What are the other ones? What else do we have in here? Excessive fines cannot be imposed, and we see that all the way back to the Magna Carta. The fine needs to be it has to fit the offense. If you've committed a fairly minor offense, they can't fine you $1 million. So it's again, this is subjective, but a court could look at the fine and determine whether that was an excessive fine based upon the crime that was committed. Finally, we have the most interesting one here, I think, is cruel and unusual punishments are forbidden. Notice it says cruel and unusual, not cruel or unusual. It's both cruel and unusual. So what do we mean by that? Well, if you get sentenced to life in prison for killing someone, is that a cruel punishment? It might be, but it's not unusual. So it has to meet both criteria, cruel and unusual. What are some of the old ways that we use to punish someone for committing a capital crime or treason? There have been other ways of taking your life, for example. Instead of, in Florida, primarily we use lethal injection. But what are some of the other ways of executing you? We could hang you. In the old days, they would chop your head off. They even had ways that were particularly cruel, called drawing and quartering, which really means that they would cut you open. Is that cruel and unusual? Most definitely. We don't use those methods anymore. Firing squad is still available. Gas chamber is used in some cases. But in death penalty cases, generally what the U.S. Supreme Court has said about death penalty cases is the Constitution does authorize us to take your life if we use due process in reaching that determination. The Fifth Amendment says that. Um, but if we do that, if we decide that execution is needed, we have to do it in a way that does not add unnecessary pain to the procedure. I mean, death is painful, but we need to use methods that don't add unnecessary pain. So the methods that we currently use, lethal injection, firing squad, a gas chamber or gas by gassing you to death. I think recently they used nitrogen gas to execute someone. They just fed it into a mask that was on his that he had to breathe in. The court has said that those are okay because they don't add unnecessary pain. Now, the death penalty was deemed unconstitutional for a brief period of time. In this case, Gregg versus Georgia. Oh no, I'm sorry, that's not the right case. Let's pull up the right one. Furman is the right case. In Furman versus Georgia, the United States Supreme Court found that the death penalty was unconstitutional. And the reason why they said that was that the way that we did death prosecutions at the time, if you were convicted of child murder, for example, the only punishment was death. And so if you had, for example, a racist jury, and they made a decision that they just didn't like you, maybe because of your race, they would find you guilty. And because that jury found you guilty, you were going to get death. And the U.S. Supreme Court felt that it was too subject to corruption. It was too subject to the whims of possibly racist jury. And so they struck down the death penalty nationwide. One of the consequences of that was that many people that were on death row had their sentences commuted to life in prison. If you remember Charlie Manson, for example, he was on death row in California for killing Sharon Tate and a number of other people. His death sentence was commuted to life. And so he served out the rest of his term until he died in prison. Well, subsequently, the states found another way to do this, a better way to do this. And this is the way that we do it now. And that case is the case that I showed you a minute ago, Gregg versus Georgia. The way we do it now is we have a bifurcated system. First, we have the trial jury decide whether you did it. And then after we decide whether you did it, they move on to the sentencing phase. The first phase is called the guilt phase. The second phase is the sentencing phase. And in the sentencing phase, more evidence is put on to allow the jury to decide whether death is the proper punishment or maybe something less than death. The U.S. Supreme Court said that mechanism passes constitutional muster. It doesn't violate the Eighth Amendment. And so those states that have the death penalty, that's the method that they use. So, all right, let's move on from the Eighth to the last two, the Ninth and the 10th Amendments, and we're going to cover these fairly quickly because they're easy to cover. In the Ninth Amendment, it says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And that just means that just because we've identified these rights contained in Amendments 1 through 8 doesn't mean that there are not others which we haven't identified. And we already know for a fact that the U.S. Supreme Court identified the right to privacy as something that is not found expressly in the Constitution, but it is a right nevertheless that we have. So finally, Amendment 10. This is the States' Rights Amendment. It says powers not delegated to the United States by the Constitution, meaning the federal government, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. So this says it's something that the federal government has not taken a position on. The states have the authority to do what they want to in those areas. The states have some rights. Okay, we have gone through the entire Bill of Rights. Thank you for your attention. In our next meeting, we will discuss the remaining 17 amendments, number 11 through 27.